to us about lifelong learning. And, we just look at what is topics that will share and that will basically enhance people's information. And I'd also like to thank, our webinar team, the team at the office, Media Fella, Albert and his team, and also the Grill Room and Sushi Bar in Brooklyn, who we are working in association with. You can see we're hosting from this beautiful, newly built cigar bar. Would like to thank them for hosting us. At that point, I'd like to hand over to Suvi to introduce herself, and she'll hand back to me so that we can start with the proceedings of the day. Thank you so much.
Thank you, Anastasia, and thank you for inviting me to speak in this event. It's absolutely my privilege to be talking to you this morning. So like said, my name is Suvi Julin, and I come from a company called Berggren from Finland. I'm a technology-oriented lawyer, according to Finnish terminology, a licensed legal counsel, so a practicing attorney. My passion lies in data protection and privacy, intellectual property, and generally in technology-oriented law and commercial contracts. I also do a lot of strategies and process type of audits and trainings, especially in the field of data privacy and also in the field of intellectual property. Interestingly, they are fields that have now been also kind of hitting together, especially in the field of patents in Europe. That would be an interesting talk to an otherwise. Yeah. So I think we are good to go with the short introduction. So Anastasia, please go on with your topics first.
Thanks so much. So the process that we'll be taking this morning, we didn't prepare slides because we find that when the talks are done like this, it becomes much more interactive. And, you will have an opportunity to ask us questions on the chat. My team is ready to take questions, and we will try and use the last 10 minutes to basically answer any questions. So I will be speaking for the next 10 minutes, and I'll hand over to Suvi, who will give us her perspective from a European and EU perspective. And we will wrap up at the end and give you 10 minutes for questions and answers. Do not panic. If we are not able to cover all your questions, we will give you our email details, and then we will try and respond to you offline. Okay, without further ado. So in South Africa, we have recently had the Protection of Personal Information Act of 2013, which aims to regulate, the protection of personal information, and also, make sure that there is privacy when that information or the data is being processed. So I just want to read to you, a little bit about the Act and the preamble, because that will basically set the tone and get people to understand why we have a POPIA, because I think people have a very limited view to what they think POPIA is. So I just like to read and say the purpose of the Act is to promote the protection of personal information processed by public and private bodies, to introduce certain conditions so as to establish minimum requirements for the processing of personal information, to provide for the establishment of an information regulator, to exercise certain powers and to perform certain duties and functions in terms of this Act. The Promotion of Access to Information Act, to provide for the issuing of codes of conduct, to provide for the rights of persons regarding unsolicited electronic communications and automated decision-making, to regulate the flow of personal information across the borders of the Republic, and to provide for matters connected therewith. So just from reading that section, you can already see, the different areas that the Act is touching on. So it introduces the conditions to set minimum requirements, so there is a baseline that you need to work from. And it relates to personal information. And it also establishes the information regulator that's already established, and it's already functioning very well. And it also talks about the Promotion of Access to Information Act. We call it the BAIA. BAIA, we've been coming along with it for a very long time. And it was, under the housing of the Human Rights Commission. So that is, if you look at asking for information from an entity, that there's a certain process that needs to be followed. And if that entity does not want to give you access to that information, they must give you reasons, and there's a whole step to be followed. So if you look at it, it's a very interesting juxtaposition where on the one hand, we're protecting information. On the other hand, we're actually saying that people need access to information. So there's a very fine line to actually balance. The other important one is the unsolicited electronic communications, known as spam emails, that people get in their inboxes. So we unfortunately won't have enough time to talk about that. Suvi and I just agreed that there's just too much scope to talk about that. But just keep in mind that that is where this now regulates the spam emails, and then also automated decision making, which is decisions that are taken outside, of any human, intervention that affects a data subject. The last and also critical one is also the transferring of personal information across the borders of the Republic. So any company in South Africa that actually shares information outside of the Republic needs to meet the minimum requirements of their country where they are sharing, and vice versa. Suvi will be talking about that, talking about the third country. But if you just look at how, just the introduction of the Act, it's very clear on what the purpose of the Act is. And also just to state that the Act was also, based on the Constitution, because the Constitution gives us everybody a right to privacy. But as you know, even if people have got a right to privacy, those rights can also be limited. So it's interesting to see how the POPIA has tried to deal with that balance in that sense, because there are exemptions, to your right to privacy. We will try and touch on it a little bit, on how those rights are limited by the legislation. And where Suvi fits in as well is, if you look at the Act, it says there is to regulate in harmony with international standards the processing of personal information by public and private bodies in a manner that gives effect to the right to privacy, subject to justifiable limitations that are aimed at protecting other rights and important interests. So that is where the cross-border sharing of information comes in, because we're not an isolated entity. And once we subscribe to privacy laws, there are other laws now that we need to make sure that we meet the baseline of outside of South Africa. Just by way of interest, Nigeria also has their own data protection laws. It's called the Nigeria Data Protection Regulation of 2019 that came into effect on the 25th of January in 2019. So you can also see that now that we have POPIA, if we have to be communicating, say, with our counterparts in Nigeria, then there's already a baseline, of how we can share the information. Zambia's president has also issued the Data Protection Act, so that is also the very, very beginning stages. So you'll see that on the continent, we are all now trying to align ourselves in terms of how we deal with data and privacy for personal information. For me, another interesting aspect of the Act is, understanding the different definitions. For example, if you look at data subject, it's basically the person to whom personal information relates. So it's everybody, it's you, it's me, it's everybody. So, and children as well, and so you need to look at the impact of this Act on everybody and how it's going to impact your information being shared, whether you're transacting with a company, whether you are buying something online. If I'm shopping, say, on Superbalist, and the shop that I'm buying from is overseas, in the US, that is my personal information being traded, in cyberspace. And I also find it interesting that, personal information, it only relates to an identifiable living natural person, and where it is applicable, an identifiable existing juristic person. So, and it breaks it down as to what that personal information is. And also it talks about another interesting aspect of it is the purpose of the Act, where they're saying they'll have to balance the right to privacy against other rights, particularly the rights of access to information. And at some point, it also talks about international standards. So you'll see that when this legislation was written, it wasn't written for us to be in isolation, but it needs to be read broadly looking at the impact that it might have, in other jurisdictions. And the beauty about legislation is it's developed basically by case law. So I'm excited to see, the cases that are going to come out of this, because that is now how we will be building precedents and, just evolving the legislation, because I'm sure there are people who are going to be challenging some of these provisions. And also in case of data breaches, it's going to be interesting to see how the courts actually deal with this, so that we can have those precedents. Some cases might even end up in the constitutional court, and it will just be beautiful to see how everything, unfolds at that point. So I can talk about so many other aspects of the Protection of Personal Information Act. Most people think it only relates to emails, but it's much broader than that. There are also other legislation that is impacted by the POPIA. For example, the ECTA, the Electronic Communications and Transactions Act. So you don't just read the POPIA in isolation. As I've mentioned, the Public Access to Information Act, is also impacted by this act, and many other acts. So for companies that have compliance universes currently, they will also need to relook those compliance universes and see where this legislation touches on. I've also had people saying that most of this applies to only HR, because HR keeps people's details and their CVs, but that's not true. If you've got an IT department, they keep just as much information, if not more, than your human resources. So it's not a human resource issue. If you're into marketing, how you deal with that information. I think this will also then impact some of the competition laws in terms of how, privacy is dealt with in that sense. And so my view and advice is that, people need to take a much broader view to this. And when you set up your programs internally, you need to make sure that those programs look at all other aspects and not just the ones that are hyped up, that, like, do you know POPIA, and then it's HR and just emails, but there's a lot. And if you look also at the penalties, you would want to make sure that you understand, what those penalties involve, so that you can make sure that whatever programs that you actually build within your program, they actually work around making sure that there is a lot of compliance. And currently, the entire act is not in effect, because there are some transitional arrangements, and Suvi will be touching on how they dealt with those transitional, arrangements, where this act will be fully implemented on the 1st of July, subject to if the minister does not move the date. And everybody had 1 year to actually implement and make sure that we conform, to the act. That also impacts the South African Human Rights, Commission, because now their functions are also impacted by, this legislation coming in. So my time is up. So at that point, I'd like to hand over to Suvi, to give us her perspective from the EU and how they dealt with this area of law. Thank you.
Thank you. Thank you very much. I think this was a great introduction and view to the topic. And I believe it's really why I was asked to speak in this event is that, well, the EU's General Data Protection Regulation, commonly known as GDPR, has now been effective and fully implemented in the European Union for almost 3 years. Full implementation was started in May 2018, and it was preceded by a 2-year transition period. So a period in accordance with the regulation to award and allow all organizations to which the regulation applies to get themselves ready and become compliant with the GDPR. 2-year transition period sounds long, but in fact, when it was started in May 2016, I think there are a couple of viewpoints that need to be highlighted, and you are probably recognizing them. I think you might you might know the same ideas, same feelings that I would like to raise here. First of all, GDPR, exactly like POPIA, applies to both public and private organizations for all kinds of processing of personal data, unless it is purely for private purposes in the area of private life. Otherwise, GDPR in general applies. And in that case, when the transition period started, we were not without data protection legislation in Europe. Each country, each European Union member state had a data protection laws in place. They were more or less in conformance with the data protection directive, the predecessor of the current regulation. And directly where the regulations in the EU are directly applicable law in each national country, in each member state, directives are of nature that they must be nationally implemented within the national laws. So there was already some sort of a harmonization existing. However, there was a lot of, let's say, fundamental changes when GDPR became in force and the transition period started. That were not understood by the companies especially. And I think bigger companies were able to start more quickly. They understood that there are fundamental changes, that the data processing principles have been made more visible. There is now a requirement of accountability, that instead of just saying that you are compliant with the current regulations, you need to be able to prove that you are compliant with them. And this created a lot of disbelief. Like, no, but no one has before required us to meet certain minimum standards or provide certain documentation or have certain processes in place. It was enough that we said that we are able to do this. So this created a lot of disbelief, and it probably sounds rather familiar. As well as I think one of the biggest issues was really that requirements for the minimum, the kind of level that you need to meet, that you need to be in par with, was raised. Although the data processing principles as such were there before as well, the bar for them became raised because requirements for the minimum standard were laid out. And many companies, especially in small and mid-size, were really thinking that, well, this really, like Anastasia just said, well, this used to apply only to HR, or if you process health data, or if you deal with emails and collect marketing information and keep up marketing registers. No, it applies to all. It applies to all personal data processing that you do. And this is really the key here. I think it's now the same thing with POPIA, that it applies to all kinds of personal data that you process. The concept of personal data under POPIA and under GDPR is actually very similar, almost identical, I would say. It covers exactly the same things. It starts with the idea that it's data that becomes, according to which a person, an individual, becomes identifiable, either directly or indirectly, in a way that when you combine certain data, the person still becomes identifiable, although one part of the data alone would not make it identifiable, but combining the data makes it identifiable. For example, a good, let's say, example about this is currently a big hot topic in Europe, IP addresses. IP addresses in certain cases are considered to be personal data. We could talk about it for another hour, so I'm not going to go that topic much more detail. But let's just say that there is a lot of data that indirectly may become personal data, and you need to be aware of it. Well, the transition period. The first year probably went by so that bigger companies did the work. Smaller companies decided that this cannot apply to us. Unfortunately, it did. When we met January 2018, the principles and the kind of fundamentality of the change had started to sink in. So companies and other organizations processing personal data started understanding that this will have great impact, that they do need to take actions to become compliant with the GDPR. And as there is the principle of accountability, which in case of GDPR means that instead of just saying that you are compliant with the GDPR, you need to be able to prove it by providing, for example, documentation. So everybody started creating documentation, a lot of documentation, privacy notices, descriptions of data processing, descriptions of data security. Part of the documents that should have been there before, part of the documents that now somebody raised it, oh, but we do need to have it. So it started with creating of documents. And problem here was that we were still, in many cases, based on the best guess of what the regulation actually means with certain documentation. As we are talking about European Union, there is always also the question of each member state being an independent country, having national laws, having a different language, and the regulation is translated into each of the languages. There was a little bit inconsistency with, for example, translations maybe at first place. And for example, in case of Finland, some of the terms were translated in accordance with previous personal data and privacy legislation, and they appear to be same concepts, except they were not. So it created a lot of hassle and a little bit of chaos. And finally, don't be surprised about this. Or probably you are not surprised about this. It all started actually probably clearing out approximately 3 weeks before the full implementation started. So we got first real guidelines from the data protection authorities, first confirmations that how certain terms should be interpreted, what is a privacy notice, and what is an internal description of data processing actions, that they are actually two different things. They are not the same. It had not been maybe fully clear before that. So just as a practical example, there might be a lot of questions during the transition period, and you might be getting answers very late. So don't get scared, just be prepared for it. Implementation time, the transition period was definitely needed. 2 years sounds long, but it turned out to be short. And most of the companies, let's say that by May 2018, exactly on 26th of May, when it became when the GDPR became fully implemented, most of the companies were probably like less than 75% compliant. And everyone knew it. So as a professional, let's say that I was not worried. I was just saying that do take your actions. Don't trust that what you have done now is something that will last. It will evolve. We need to keep following up decisions from the authorities, guidelines from the authorities, how the practice will evolve in each of the member states. And we need to keep following it up. Now, after 3 years, we are more or less finding the baseline. We know how things have been evolving. We have guidelines in place, more guidelines from the, for example, from the general authority, from the European Data Protection Board is coming up, and they actually set the baseline for us. They provide interpretation of the regulation that we need in order to be able to function on daily matters and setting up processes. And we have now been transferring from, let's say, providing documentation to meet the requirement of accountability to creating processes that actually create the accountability. Having place processes on how the personal data is being processed and handled. I think you will more or less be meeting a similar kind of process in South Africa. So be prepared for evolving process. Be prepared that litigation decisions by authorities or cases tested before the court will change the interpretation or will provide you more interpretation on what the practice should be. And that processes and documentations, practices that you set up now must evolve over time. Data protection and privacy as a function within an organization is something that should not be a yellow post-it note stamped on the wall and said that we have a process. Instead, it must be something that becomes implemented in what you do in your actions at all levels, at all times. And at that point, you are also then able to meet the compliance with other countries. Then, saying that, let's talk a little bit about the differences or similarities between GDPR and POPIA, because this might be something that you find interesting, that you might want to know. This could be a talk for another 5 hours, so I'll just try to be brief and give you a little bit of overview highlights. I did a bit of education of myself for POPIA and reviewed the regulation itself, and then reviewed a couple of rather well interpreted documents where comparisons between GDPR and POPIA were made. And in general, the basic terminology appears to be rather similar. The basic principles appear to be rather similar. And if I would have to point one big major difference, that would be that GDPR, like any EU regulation, tends to be a little bit deep down to detail and provide rather in-depth instructions on how certain things must be done or what the minimum requirement actually is. And that is simply because it aims to harmonize the practices across member states, so across a bunch of independent countries, 27 per se. So it's understandable. It goes a little bit more deep down into detail. Then there is certain things that I paid attention to, which might be good to know. Personal information as such, like I said, is understood in a very similar manner, as well as data processing is understood in a very similar manner. Automated decision-making is also understood in a very similar manner, and it's a really important topic under the GDPR and also, I believe, under the POPIA. There appears to be a slight difference in certain key concepts and where the legislation extends to. GDPR concerns both data controllers. Data controller in terms of POPIA is a responsible party, the party who is more or less the one for whose purposes the data is being processed to. So who is responsible for collecting the data and using the data for certain purposes. In terms of GDPR, we call it data controller. In terms of POPIA, it is responsible party, occasionally also referred as processor, I believe. And that might be a confusion with GDPR, because in GDPR, we have a data processor, which is more or less same thing as operator under POPIA. So it is a party who processes the personal data on behalf of the data controller or on behalf of the responsible party, and in accordance with, under GDPR, in accordance with the instructions of the responsible party, of the controller. And where the GDPR actually extends to processors as well, our previous legislation did not extend to processors per se. I don't think POPIA directly extends to operators. It does say that the responsible party is the one who carries out responsibility for all processing, and they do need to have agreements in place with the operator to meet, for example, requirements on data security. Whereas the GDPR is very detailed on this. It even defines independent responsibilities for data processors and requires that the data controller make sure that there is an agreement between the data controller and data processor, and even lays out minimum requirements for that agreement. It's called a data processing agreement, not very surprisingly. So this is kind of a big difference maybe, but in a sense, it means that if you deal with European parties, South African company might become in a position where you are a data processor for a European company, or you use a European company who is actually a data processor according to European legislation in terms of what they do and in connection to you. So this might lead to you, firstly, to a situation where we initiate a data transfer, and where you need to be compliant with the laws and regulations within South Africa, but your party in Europe needs to be compliant also with the European legislation. And it means that, for example, agreements that you need to execute, either they need to meet the requirements of both countries, or you might end up having a bunch of agreements meeting the situation. I'll talk about the data transfers a little bit later, because in terms of POPIA also, I'm seeing something that will probably in future be a great advantage, or will create a situation a little bit more uncomplex, hopefully. Then about the differences and similarities regarding GDPR or between GDPR and POPIA. One big issue in European Union has been how personal data becomes something that is not personal data anymore, or data sets containing personal data become something that are not regarded as data sets having personal data included. So when they are actually limited out from the scope of privacy regulations, and it's called anonymization of data. Under terminology of POPIA, I believe you talk about de-identification. It's more or less a same thing. The basic concept is very, very similar, and it's an important concept. Under GDPR, anonymization of data is a data processing action, after which data becomes not personal, containing personal data anymore. It is an action where the personal data is disconnected from the other data in a way that they cannot be connected back together anymore. No connection between them can be made no longer. If you leave an identifier within the data set that enables you to connect the data set back to the personal data. In terms of GDPR, we talk about pseudonymized data. POPIA itself does not introduce this kind of a term, but I would say that the same idea lies in that if there is any kind of way to connect a data set back to the personal data, it still remains personal data. Anonymization is also challenging, and in the future, it requires actions by all the data controllers, because still anonymization might actually lose its effectiveness over time when technologies evolve, algorithms evolve, artificial intelligence is developed. So it's something that it's going to be probably in focus in the future, and quite a lot in focus, especially because our societies are becoming more and more data intensive. They use data for all purposes, from human resources, from recruitment, from client creation to marketing. Anything almost you can think of, to development of new technologies, for example. And this is something that is going to be an interesting topic in the future, something that needs to be probably, and the practice under both POPIA and GDPR will evolve. The baseline, however, looks very similar. Then the key principles, one of the key foundations of both regulations is the lawfulness of processing, that you need to have a proper legal basis for processing. And I think we are in good situation between GDPR and POPIA here. The legal bases seem to be highly compatible with each other. The personal data, all processing of personal data always requires a legal basis according to both legislations. And it can be a performance of a contract. So for example, when you are providing services from one party to another, you are able to process personal data to the extent that execution and performance of the contract requires you to. You could be relying on consent. Explicit consent, when the consent is required, is defined by both legislations. There are minor differences, but let's say that it's mostly quite compliant. Certain differences might become in question, for example, in case of direct marketing and these kind of things, but they are really specific topics and need to be considered case by case how they are arranged. Probably also a topic that could be talked more about in detail. Also, authorities under the GDPR have a right to process data to the extent their administrative tasks and their role requires. Same idea is within POPIA, and it must be applied in together, for example, your other legislation, the role of an authority, the legislation on which the authority's rights and role there, or the extent of their authority is based to. And then otherwise, there is the legitimate interest to process. Same concept exists in both legislations. The interpretation is maybe slightly different, but the idea is very same. However, in very European Union fashion, in a manner that is, let's say, typical for GDPR, there is a requirement for balance test, which more or less says that you need to balance your processing interest together with rightful expectations of the data subject, and it has rather detailed definition of what kind of things you need to document for the balance test. Balance test as such does not exist under POPIA, I believe, but let's say that the basic requirement is still the very same. And I think these are point of views that more or less highlight the same aspects. It all starts in both cases, understanding what kind of personal data you are processing, for what purposes you process the data, ensuring that the data subjects, the individuals that are registered, are constantly being informed on the data processing. There's a slight difference when they should be informed, and where GDPR says that they must be informed prior, at the time of collecting the data. POPIA says that prior to collecting the data, for example. It looks like POPIA might be a little bit stricter actually in this case, which is not a bad thing. I think it's actually good. The requirements, what kind of information the individuals must be provided with, it's very important that it's given out in detail. So creating transparency is kind of very founding idea in both legislations. And it more or less starts with the idea that personal data processing is allowed within the limits of your regulation, as long as you are being transparent of what you do. You don't try to hide your processing actions. And when needed, you seek consent. You provide information to the data subjects that you are processing their data. You don't own the data. The data belongs actually to the persons whose data you are processing. You just have a right to process it in limits of the applicable laws and regulations. And also, then the responsibility of the data processor or the responsible party, that when you process the data, you need to take the responsibility of your processing actions to ensure that the data is properly secured, considering the nature of the data, purposes of your processing, extent of your processing, how much you process the personal data, how long you process it, so that you don't process personal data that you don't need to process, that you only process data for the purposes that you informed the data subjects that you are processing the data to. It's all very similar between both continents, or both areas, both South Africa and in European Union. In European Union, you might be, depending on the country then to which you work with, or in case if you work with several countries, you might then become subject to a small national variety